Hi everyone, this is Rahul from WillJini. WillJini as a company specializes in inheritance, be it planning of inheritance through wills, through private family trusts, or helping families in actually assisting on-ground assistance for transferring of assets after the demise of someone, be it through a succession certificate, be it through a probate of a will. To any family right now going through a difficult period and wanting to get a probate of a will, today's topic of discussion is going to be around probate of a will. What is a probate of a will? An end-to-end understanding of what is the process associated with probate of a will, and what are the court fees, and in general, what is the duration that you can expect while probating a will. We are very lucky to have Mrs. Manisha Pant with us. Welcome, ma'am. Manisha ji has been with WillJini from its inception in 2015. She's a practicing lawyer in the Bombay High Court. She's been practicing for the last 20 years. So she brings with her a plethora of experience. Let's begin. Welcome, ma'am.
Thank you for having me, Rahul.
Yeah. So first, just wanting to understand what is probate of a will.
Okay, see, any person makes a will, no? He leaves a will. It can be in any which format. So, probate is a declaration, like a certificate given by the court that this is the authentic last will of the person. See, probate is required. We have basically we have region-wise compulsion. We have states in India. So basically, it's compulsory in Mumbai, Chennai, and Kolkata because they were considered to be a metro city. But the fact is that many states like Delhi or Haryana, they accept registered wills. If the will is registered and all legal heirs are on the same page and they are accepting the will, then the properties can be transferred on basis of the registered will. That's not an issue. But yes, probate will be required there even in case where there is no direct legal heirs, like there is no kids, no grandchildren, no spouse, no parents. So these are all class 1 legal heirs. Second thing is that if the will is contested, if one of the legal heirs is not accepting the will, then also probate will be required.
Having understood this, now can we understand a little bit about the process of a probate? Who applies for a probate? After that, what are the next steps that one has to do?
See, basically, each probate or ideally each probate should mention a executor. So it's a liability of an executor to obtain or apply for a probate. So once the person is deceased, he dies, it's a responsibility of the executor to take or get the original with him, and he has to start the process of the execution or probate of the will.
Okay. So every will have an executor. A will can have multiple executors as well?
Yeah. See, ideally each will should have an executor. In case there is not an executor or there is no executor name, then one of the legal heirs or the beneficiaries, they can do this process. They can start this process. Only it will not be called as probate. It will be called as a letters of administration with will annexed. Okay. And there can be a multiple executors. Suppose there are two executors, or both of them can apply, or one of them can apply, the other one can resign.
Okay, once somebody applies for probate, what are the documents that are required for the person, for the executor to apply for the probate?
See, basic document is the death certificate of the deceased, original death certificate, and the original will. He should be in possession of these two important documents. Then other than that, his property documents. At least he should have the entire list or the schedule of his assets, movables and the immovables, all of them. Outside Maharashtra, you will require the property documents also. So suppose it's a shares, then you will be required to show the share certificate if it's a physical share. But ideally, he should be having at least the death certificate and the will.
Okay. So all of the assets that are owned by that individual who's gotten deceased, that needs to be scheduled on a piece of paper, which we call a schedule of property. So one question that people ask us often is a different probate required for every property, or one probate takes care of all the assets that was owned by the deceased person?
No, there is only one probate for one will. You should mention all the properties ideally. But just in case you have not mentioned one property or there is some mistake in the mentioning, you can amend the petition and get it changed whenever you come to know this.
So let's suppose all the properties have been the information has been disclosed and the petition of the probate has been filed. Right? Then what are the next steps that happen?
See, basically the executor will file this everything. Then he will also need an affidavit of one of the witnesses. The witnesses who is the attesting witness to the will. So he needs his affidavit. He will state that I knew the deceased from whatever years and how he knew them, and he will identify his signature, that I saw the deceased sign the will, so it is his signature. He will identify the will. Then he will say, I also affix my signature. So that's the way in which you prove the will.
Okay.
So that affidavit also has to be annexed with the petition.
After that, what happens?
After that, what happens is that in there is some office processes, in at least in High Court, there is something called as an office objections. So you remove that, you comply with all the office objections, your petition is numbered, then it is taken up for hearing.
Okay.
And the court will issue notices to all the beneficiaries and the legal heirs, whoever are there.
Okay.
They will get the notices. So at this point of time, if everybody is on the same page and everybody is contesting to the affidavit, we will not typically send you the notice, and then you can give your consent on your own.
Okay. How is the notice sent? So let's suppose there are 3 legal heirs for the person that has gotten deceased, right? Is a notice sent to each of the legal heir, and how is it sent? Let's suppose some people might be in India, some people might be outside of India as well.
Okay, see, basically there are 2 types of properties, immovable property and movable property. So the notice service is given to the bailiff. The bailiff will issue the notice. He will either send it to the post where the person is residing in India. If it is outside India, he can send it by email, he can send it by WhatsApp also. Both the things are acceptable. Or if he doesn't have anything, he can send it to you via social media also, if that your account is known to everybody. But
Okay.
email and WhatsApp is an acceptable way of service, and that's a faster one. For anybody residing outside India, that's acceptable.
Okay.
I found it.
And then they essentially wait for the consent of the legal heirs.
Yeah.
Once the consent is provided by the legal heirs, then the process moves
Yeah.
forward.
So once this process typically takes 90 days. So after that 90 days is over, any point of time the matter is again taken up on the board. The court will see that you have complied with everything, The will is there, the death certificate is there, all legal heirs are mentioned, they are served, they have been informed, their consent is there. So once they see everything is in place, then they will grant you the probate.
Okay. So you're saying 90 days is required for the consent to come in, for due diligence of the property to happen. Are there dues that are there on the property or not, so on and so forth. And after all the compliances are taken up by the court, they understand that everything is okay, everything looks good from that perspective, then the probate is essentially issued.
Yeah, the order is granted. Then
order is
another month or so, you will get a proper order of a court, which is signed. It has a sign and seal of the High Court or the court, any court, and wherein you get the original will back to you.
Okay.
And they will say that this is the will, this is the probated will, and you have to distribute the property as per the will.
Okay.
And it's the responsibility of the executor to see the properties are distributed as per the will. In between, he has to also give an administrative bond, to the court in this process in between, wherein he says that I will take the property and I will distribute it as per the will, and I will give you a report. So he's bound to give the report to the court within a year that these are the properties that I have taken and this is the way I distributed it.
Okay. So an administrative bond is also part of the probate
Part of the
process.
entire process, yes.
Okay. So this sounds like a lot of work. How long does this entire cycle take?
See, usually from the date of filing, usually this happens within 10 to 12 months.
Okay.
That's how it is.
So 10 to 12 months from the date of filing is when you'll get the physical copy of the
Yes.
probated will along with the original will
Yes.
that you had submitted during
Yes.
filing of the petition.
Yes.
And then the society office or the bank or whoever it is that is asked for a probate will have to comply with the probated
Right.
will and then sanction the properties
Right.
or transfer the assets accordingly.
Right.
Right. Anything else that you felt was missing that you wanted to speak about?
So there is a recent amendment, not very recent, so which says that if your flat is there in a cooperative housing society, then the transfer will not be only on basis of nomination. You have to get either the probate. So if you have a will, you have to get a probate.
Okay. I think one thing that we missed covering is what is the legal fees or what is the court fees for the entire process of a probate?
See, if your property value is above 11 lakhs, then 75,000 rupees is the maximum court fee that you will have to pay. That's
Okay.
in Maharashtra. But if your property is less than 11 lakhs, then there are different slabs which will apply. That start from 10,000 rupees.
Okay, so it's a variable fee from 10,000 to
To
75,000.
75,000.
The upper cap is 75,000. Any property over the value of 11 lakhs net worth qualifies for the upper cap of 75,000. That needs to be paid.
Yes.
Okay. Thank you so much, Manisha ji. That was a wonderful session. You have demystified the entire complicated process of what a probate is, as well as the end-to-end formalities or a procedure that is required to
Right.
execute a probate. Yeah, I hope all of our viewers have been able to understand this slightly complex topic, and yeah, if there's anything that you need in your process of filing a probate, you can always contact us at WillJini, and we'll be happy to help you. Thank you.